Welcome to Bankruptcy Bytes, a video series presented to you by the United States Bankruptcy Court for the Eastern District of Missouri. I'm Matt Rodman, attorney advisor to the Clerk of Court, and today we're going to compare and contrast Chapter 7 cases and Chapter 13 cases. These are the most common types of case filed by individuals. Before we get started, just remember, the clerk's office and its staff are unable to provide legal advice, as we have a strict statutory obligation to always remain neutral. We can tell you the rules and procedures the court follows, but we can't tell you what to do. Everyone's situation is different, and for the best individual assistance, the court strongly recommends that all debtors and prospective debtors speak with an attorney to get expert advice on the right path for them. Chapter 7 and Chapter 13 cases get their name from the portion of Title 11 of the United States Code in which they appear. Title 11 of the United States Code is also referred to as the Bankruptcy Code. There are some similarities between these two types of bankruptcy case, but there are many differences. The information here is intended to give you a broad overview of the similarities and differences between these two types of case and how to distinguish between the two. This information is not legal advice, and you should consult an attorney to determine the chapter that is best for you. Chapter 7 is the most common type of case filed by individuals and spouses filing jointly. Generally, Chapter 7 is best suited for those who do not have a steady income to rely upon to repay their debt, or someone whose debt far outpaces the income they have with which to pay those debts. Please note, eligibility for a discharge of debts in Chapter 7 is contingent upon having not received a discharge under Chapter 7 within the last 8 years. When a Chapter 7 case is filed, all of the assets and property in the debtor's possession become what's known as the bankruptcy estate. The bankruptcy estate is turned over to the Chapter 7 trustee assigned to the case. The Chapter 7 trustee will sell or liquidate all of the assets and property comprising the bankruptcy estate to repay creditors to the extent possible. Pursuant to Missouri law, certain exempt property will not be sold to repay debts. This type of property generally includes items needed for everyday living or to earn a livelihood. Examples include a motor vehicle, principal place of residence, health aids, clothing, household appliances, and other things. Debtors and prospective debtors are encouraged to speak with an attorney to learn more about Missouri exemptions. Lastly, a Chapter 7 bankruptcy case appears on your credit report for 10 years after filing. This is true whether you receive a discharge or not. Chapter 13 is the second most common type of case filed by individuals and spouses filing jointly. Generally, Chapter 13 cases are best suited for those who are steady wage earners. Please note, eligibility for a discharge of debts in a Chapter 13 case is contingent upon having not received a discharge under Chapter 13 within the last 2 years. Unlike a Chapter 7 case, a Chapter 13 case requires repayment of at least a substantial portion of the debts the debtor owes. The amounts the debtor must repay is based upon a court-approved payment plan lasting between 3 and 5 years. Determining the length of your Chapter 13 plan, your monthly payment amount, and the amount owed to each creditor is not an easy task. The court strongly urges all Chapter 13 debtors and prospective Chapter 13 debtors to speak with a knowledgeable bankruptcy attorney to help ensure that they propose a Chapter 13 payment plan that can be confirmed by the court. Typically, a Chapter 13 debtor is able to retain their property, as Chapter 13 allows them to continue making payments on their property to retain it. A Chapter 13 bankruptcy case will appear on your credit report for 7 years from the filing date. This is true whether your case is dismissed, closed without a discharge, or proceeds to a discharge and then is closed. Now that we've discussed a little bit about how Chapter 7 and Chapter 13 cases are different, let's highlight some similarities between Chapter 7 and Chapter 13 cases. First, both Chapter 7 and Chapter 13 cases enable the debtor to receive a discharge of most of their debts. For public policy reasons, some debts will not be discharged. These debts include, but are not limited to, child support, spousal support, certain tax liabilities, and criminal restitution payments. Next, eligibility to file under Chapter 7 and Chapter 13 is based upon the outcome of your means test. The means test assesses whether you retain ample funds each month to repay creditors. If you have sufficient disposable income to repay creditors, you may be ineligible to file under Chapter 7, but you may still be able to file under Chapter 13. Additionally, both Chapter 7 and Chapter 13 cases require completion of a credit counseling course before filing the case and the completion of a financial management course or a debtor education course before you can receive a discharge. With few exceptions, the filing of a Chapter 7 case and Chapter 13 case results in the imposition of the automatic stay. The automatic stay prohibits all debt collection efforts against the debtor unless the creditor obtains court approval first. This video is intended to highlight some of the key differences between Chapter 7 and Chapter 13 bankruptcy cases, as well as highlight some of their similarities. The decision whether to file a bankruptcy case, let alone a Chapter 7 or Chapter 13 bankruptcy case, is not one to be made lightly, as the decision could carry significant financial and legal consequences. The court strongly urges all debtors and prospective debtors to speak with a bankruptcy attorney. A bankruptcy attorney will be well versed on the bankruptcy code, the federal rules of bankruptcy procedure, and the local rules of bankruptcy procedure. This knowledge forms the roadmap for a successful bankruptcy case. If you would like to speak with an attorney regarding your recent or upcoming bankruptcy filing, the Bar Association of Metropolitan St. Louis hosts the St. Louis Bankruptcy Pro Se Assistance Program. This program offers cost-free 30-minute sessions with an attorney where the prospective or current debtor can get the answers to some of their questions. To schedule an appointment, you may call 1-844-758-4059 or schedule online at www.bamsl.org/bankruptcy. Thanks for tuning in to compare and contrast Chapter 7 and Chapter 13 bankruptcy cases. This has been part of the Bankruptcy Bytes series presented to you by the United States Bankruptcy Court for the Eastern District of Missouri. I'm Matt Rodman, Attorney Advisor to the Clerk of Court. On behalf of the Clerk and the entire Clerk's Office staff, we hope you found this information helpful, and we wish you all the best moving forward.